He violated the Fourth Amendment, but he didn't realize he was and didn't intend to. So we let it in.
We are going to take a look at Justice Scalia's incorrect interpretation of the Fourth Amendment at the time of Hudson v. Michigan. And we're going to see what is the actual validation process for an infringement of Fourth Amendment rights. Is it that searches without threshold probable cause can never be the intended design of law, as it shall make no law, but searches without probable cause are allowed so long as they can be colored as unintentional local accidents not designed by law? So can you violate someone's Fourth Amendment rights as long as the law didn't tell you to do it? Or is it that searches and seizures are allowed by law, but novel individual infringements must be verified to be legitimate in each case? Scalia seemed to say accidents are allowed without examining the facts of individual cases as long as the law didn't design the accidents and create those facts. There's a difference between shall make no law in the First Amendment, which considers the systemic properties, and secure, supported by oath, in the Fourth Amendment, which creates a process to consider the circumstances of the individual case. The First Amendment is a law. The Fourth Amendment is a process for double-checking whether the law has been violated in individual cases, like a jury trial. And there's a logical reason for this difference, because government wants to outlaw speech against the government, whereas police want to arrest specific undesirable individuals under color of false reasons in the individual case by coming up with fake color that it was for a reason other than speech. Writing a law is done in a white market way in the legislature, where we're not lying about what we're doing. We're just making it illegal to insult the king. But checking whether a law is violated is done based on the murky facts of a specific case, saying it looked like this guy had a stolen item in his car when the real reason for searching him was that he insulted the king. So laws are not hidden, and we don't need a process then to bring them out, but the facts of a particular case are hidden, so we need a process to discover those facts in individual cases. The difference between a law and a process is a process needs to produce facts. The purpose of a process is not just to check what the law is, but to measure the case-specific facts against that law. So if a cop says he thought he saw political speech occurring, there's no need for a hearing on the specific facts of the case, because you're just going to throw it out. It's never allowed. A Fourth Amendment judge doesn't throw out all searches, because searches and seizures can never be the intended design of law, so that no searches are allowed, and nor does a Fourth Amendment judge allow all searches as long as the law did not specifically say you can search people without probable cause or for flimsy reasons. He's not supposed to say, yeah, you can search everybody as long as the law didn't say you can search everybody. That doesn't even have any meaning, and we're going to get to that. But Scalia says that's what he does, and we're going to get to that. But let's pretend, instead of being a process versus a law, let's pretend both amendments were a law and neither was a process, and we're going to see that in that case there's no need for a hearing in either the First Amendment or the Fourth Amendment. Because the First Amendment says the law cannot prohibit speech, whereas the Fourth Amendment kind of says, well, the law cannot penalize things that don't look like a crime by searching people who aren't breaking the law. Even though searches are not supposed to be a penalty when something looks like a crime, they're just a way to get information. But let's pretend the Fourth Amendment was a law more like the First Amendment, where the search was the penalty for breaking the law. And so let's propose that the Fourth Amendment instead said, states shall make no law allowing unreasonable searches and seizures without probable cause. Notice, this doesn't say cops can't do it. It just says the cops are breaking the law when they do it. They're breaking the law, and they'll never be prosecuted. In this case, a cop who tells a judge he saw a stolen item in a car is not unreasonable to search it, even if it turns out to be untrue. Because the law didn't allow him to lie or to search without claiming to see a stolen item, he had to lie to do it. So, in summary, a cop who says, I violated the law to search this guy's car is then allowed to do it. Illegal searches are allowed because they do not violate shall make no law. They violate what the Fourth Amendment actually says, but they don't violate this alternate shall make no law Fourth Amendment. Similar to like how a cop who crashes his motorcycle into a political campaign bus is not following a law that lets him violate speech because it was an accident. There's no validation process where a court checks a cop's driving to make sure he doesn't accidentally crash into political campaign buses. Because you're not allowed to create a system to penalize speech, so there's no validation process created for individual speech infringements. We know the cop who crashed into the campaign bus broke the law. You don't need a validation process to make sure a cop is not lying when he gives his reasons for arresting a political speaker, and to make sure they're good reasons, when the law says he's not allowed to arrest a political speaker for any reason. So the First Amendment does not need a hearing process. Applying the same logic to the Fourth Amendment, the court wouldn't check if the search was reasonable. The court would check if the unreasonable search was a violation of law. If the unreasonable search was a violation of law, okay then. Because all the amendment says is you can't make a law that says you can search without probable cause. There's literally no point in a judge looking at each case to say illegal searches are illegal. Was that search illegal? Yes. Therefore, it's legal or it's allowed because it wasn't a case of shall make no law. It was a case of they didn't make a law, but he did it anyway. There's no point in a judge looking at each case to say illegal searches are illegal and therefore allowed. So that obviously can't be the purpose of the Fourth Amendment when the Fourth Amendment creates a hearing for the details of each case. But Scalia seems to think the purpose of the Fourth Amendment hearing is like the First Amendment, to check what the law is, not to check the facts of the individual case. Scalia would then say, well, the exclusionary rule is not in this alternate shall make no law Fourth Amendment text. Scalia would say, we don't block rights infringements that use illegal searches, we just say illegal searches are illegal, and then we don't do anything. Yep, that's illegal. Nobody made a law that said he could do that. Nobody made a law that said the cop could search your car, but he did it. And that's where it ends. No point to have a hearing to say that. It's a ridiculous version of the Fourth Amendment. Scalia says government can't design a system with the admitted intent of producing searches without some threshold of probability at the vantage point of the cop, but things which can be colored as inevitable accidents or openly admitted to be law violations do not amount to a creation of law. And so the product of searches that were presented as ill-founded, whether accidentally or illegally, not systemically, should not be excluded. Scalia says a cop who claims he misread a license plate or mistakenly thought someone had a warrant because of computer error has not violated the Fourth Amendment because from his vantage point it looked like probable cause. Either that or he was breaking the law by lying. There's no need for a hearing to determine which it was, whether he really saw the probable cause or whether he was lying, because it was either reasonable or illegal from his vantage point, and thus what he did wasn't created by passing a law. Scalia doesn't say a judge should look at what the license plate really looked like, or the judge should look whether there even was a license plate to see if it really was reasonable. The judge only looks whether it was either reasonable or illegal or accidental. There's no need for a cop to swear any facts for a judge to think which three of these it is, because it's always going to be one of these three. So there's only one possible outcome to such a hearing. And that is either there really was probable cause, like the law says there's supposed to be, or the cop lied and broke the law, in which case it wasn't made by law and they didn't pass a law that said he could do it. So it's legal and they can keep the search product. Scalia still does seem to think there's a purpose for a Fourth Amendment hearing, despite this purpose not being written in the Fourth Amendment and not seeming to be used in practice. Scalia thinks the Fourth Amendment hearing can be used to look at the general social and political system that created the infringement, rather than look at the circumstances of the particular case were legitimate. So in other words, if it's always going to be either legal or breaking the law but not made by law, then there seems to be no purpose of a Fourth Amendment hearing. But Scalia thinks the Fourth Amendment hearing can be used to look at the general social and political system that created the infringement, rather than whether the circumstances of the particular case were legitimate. So if cops are generally allowed to lie in a particular town or in the country or whatever, that's sort of like creating a law. Never mind that such a hearing is then satisfied by finding these facts out of Scalia's own biased imagination, when he just imagines that social forces don't allow cops to lie, and so he just decides there's no law saying cops can do illegal searches without even having to hear testimony from the cop, really. So Scalia, in no point seeing if the cop lied, because it wasn't a creation of law, so he says instead we're going to use this Fourth Amendment hearing to see if they passed a law that said he could lie, when he imagined social forces don't allow cops to lie. Scalia and also Justice Roberts in Hearing of the United States say, we look at the local system, and as long as there's not something about that local political system that produces such accidents, infringing speech, or searching cars without legitimate reason, the accident was not created by law. So the state has made no law abridging the right to be secure in any standard way. According to Scalia, we only need to occasionally theorize about the general political incentives and management practices of police rather than listen to facts to judge individual searches. So that's all stuff where if the Fourth Amendment was a law, was shall make no law, rather than you have to create a process to judge the individual circumstances. So now let's look at what the Fourth Amendment actually says. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation. This is different from saying the state can't create a law or system to search people for unregulated reasons. It's saying people shall be secure against illegitimate searches regardless of whether they are produced by law or system or accident. You just can't do it however it happened. You can't remove people's security without legitimate cause. And it then requires a validation system of the facts of the individual case, not of the law, a validation system for the individual case for a judge to determine if the cause was legitimate in the particular instance. If the cause was not legitimate in the particular instance, the people cannot be harmed by it, regardless of the search being an accident not created by law or system. If the cause was not legitimate, the person can't be harmed by it, regardless of the search being an accident not created by law or system. So there's an additional validation feature mentioned in the Fourth Amendment, the oath or affirmation. This is saying there must be some validation of the reasons for the search. Nobody can ever know if a cop really smelled marijuana or just lied that he did, but there is this hearing process to mitigate that the cop can lie and use false color. The cause for the search is supposed to be examined to be legitimate by a second check, in this case by a judge. The essence of this is if someone at another vantage point or with further examination decides the cop's justifications are invalid, people's security cannot be violated. Law or not, it can't be violated. It doesn't stop a cop from lying and inventing nonsense, but it is supposed to make it harder when you have this extra hearing. So there are two differences between shall make no law in the First Amendment and secure supported by oath in the Fourth Amendment. The first is that the cop's opinion or claim is not enough to justify a search, rather some secondary validation of what the cop thinks or saw is needed. The second difference is that you cannot infringe the right without legitimate cause in the specific case, regardless of whether the infringement was a creation of law or an accident. The Fourth Amendment hearing does not look at state law processes. It looks at the circumstances of the specific case. The Fourth Amendment creates extra protection against lies and accidents with validation by a judge, and by prohibiting insecurity resulting from searches found to be illegitimate, even if not intended by state law or systems. When Scalia and Roberts look at the system that created the infringement, rather than was the foundation for the particular infringement legitimate, they incorrectly characterize the Fourth Amendment as shall make no law, rather than a process protection, shall use no process without validation, whether that's a jury or a judge hearing. This actual Fourth Amendment gives the judge power to decide in an individual case that a dead body can't be used to infringe the rights of the defendant. When the search was justified by a cop claiming an item looked stolen, which turned out to not be stolen, and upon review it wasn't a legitimate cause for the search, the judge has the power to throw it out. For the Fourth Amendment to be different from the First Amendment, it doesn't matter what those exact criteria are to throw out the product of the search. It only matters that there is a hearing in each case comparing the specific facts of each case to those criteria. The important thing is that you look at the circumstances of the individual search, not at systemic errors like in Hearing of the United States. A cop can always lie that it looked like there was a crime. The purpose of the Fourth Amendment is then to check that arbitrary power by saying you have a right to a trial by judge of the individual search to see if it was just some nonsense or something faked, and then the judge, like the jury, has discretion to throw it out. So, the Fourth Amendment is more like the Sixth Amendment right to a jury trial. It's a late process roadblock of verifying the narrow circumstances of individual cases rather than a broad and general advanced law roadblock. A conviction without a jury trial has to be overturned, and a search that fails a secondary validation of whether it was legitimately justified cannot be allowed to harm someone. The purpose of the judicial review is to look at the total circumstances of the search. Those circumstances can include whether the cop was deterred or faced punishment for lying. If there was no system in place to deter cops lying, but rather they're encouraged with an incentive to lie, then the judge, like the jury, has discretion to throw it out. But Scalia gets this backwards. He says we can look at the institutional incentives not to judge the cop a liar in the individual case, but to see whether we need to throw out the search to create those incentives. In other words, Scalia says we can look at the deterrence to perjury in the local political system, and if there's not deterrence to perjury, we can throw out an individual search to fix that, and to fix the law in general, in a sort of mixed up process not actually written into the Fourth Amendment. So Scalia is sitting here not looking at individual searches to see if they're valid, but using individual searches as an opportunity to create systemic incentives, which is not written in the Fourth Amendment. Saying whether there was an adequate deterrent to perjury to allow the search is different from saying that we are going to allow the search or not to create that deterrent. So sure, a court has jurisdiction to say whether there was or wasn't adequate deterrent to perjury. The court then has no right to say they're going to exclude the search to create that deterrent if it's missing, thereby creating a legal system with the case hearing rather than weighing the circumstances of the particular search. That's not in the Fourth Amendment. If judges want to demand a deterrent against perjury, they can do that to require due process, but the purpose of the process for determining whether an individual search should be excluded is not to raise the issue of whether excluding it will deter future violations. The judge can say he thinks the probable cause in a particular case is sketchy because he knows the local cops don't face any penalty for perjury, but beyond that, the judge has nothing more to say about it. But Scalia once again goes all crazy like New State Ice, imposing his own biases and inventions into something that was supposed to be a simple hearing to double-check searches and throw out the sketchy ones. So now we get into the problem of did it look like probable cause from the cop's vantage point in Hudson v. Michigan? And the answer is no, because the cop is the one who created the mistake by calling counties until someone made a mistake. If you call enough counties, you'll eventually find a different person with the same name with a warrant. If you search enough lists of stolen items, you will eventually find an item reported stolen that looks similar to an item in plain view in the suspect's car. If you call enough states, you will eventually find a state with a car of the same model as the suspect reported stolen. In Hudson v. Michigan, the cop's investigation began before and without a crime to then find something that could be presented as the reason for starting the investigation. The cop fished for fake reasons from a bottomless pool until he was able to find something he could paint as probable cause. You show me the person, I'll show you the crime. So from the point of view of a judge, following a person around until he rolls a stop sign or whatever initiates the violation of privacy without a crime before a known crime. Scalia characterized that as just being a smart cop who knew this guy Hudson was up to no good, and so the cop checked for a warrant. But the cop was wrong. There was no outstanding warrant. The only way he could be a smart cop is if the established legal criteria allow the cop to say, I know this guy's usually up to no good, that gives me a good reason to search him. Because that is in effect what the cop did. But calling every state until you find the same model as the suspect's car reported stolen because you don't have valid search criteria but you still want to search would create a search that should be thrown out.